This is WPSL Port St. Lucie.
Time now for the Ask a Lawyer radio program here on WPSL. WPSL Port St. Lucie, the talk of the Treasure Coast, where, of course, you're invited to tune in each and every Friday morning for the Ask a Lawyer radio show with the one, the only, Stuart M. Address. Hey, I like that rewind sound in there. Pretty good. Hey, welcome again on a Friday morning to Ask a Lawyer, 340-1590. I'm going to ask a lawyer something right now. What do people ask you when they call you? What's the most often asked question?
Well, we were going to discuss that a little bit today. It's, my boss is treating me horribly.
Oh.
That's the most asked.
Oh, okay.
Most commented on.
I know for a fact that nobody here has asked you that.
No.
Okay.
Now, did you tell me we didn't do the disclaimer?
Okay, we have to do a disclaimer.
All right, folks. Here's a disclaimer. Technical difficulties, right? Here's a disclaimer. The statements of the person speaking here today are not that of WPSL or its entities, subsidiaries, parent companies, etc., agents, contractors, or anybody else. It's my opinion.
I have known all along that lawyers are the best people to ask to do disclaimers for you because they write them best.
Yes, but I didn't have to write that. I tried to just memorize what you guys say and muff it a little bit. Not too bad. All right, folks, so we sort of started the show a little bit weird this morning. That's what you have when you got Cliff doing it for you. Anyway, good morning, Treasure Coast.
We cornered the market on weird.
Now we got our real producer here. Everything's going to go smooth as silk now. So I'm glad you're here with us. I hope you will call us. It's always a little bit more fun when I'm chatting with you. And, Cliff, during his Swap Shop show and some of the promos, was talking about, me being a World Wrestling Federation lawyer, and we're going to rumble. We're going to rumble in the courtroom.
The quality of a World Wrestling Federation.
All right. Now, Cliff, I think that if you're going to make that claim, you need to give me a World Wrestling Federation name.
Okay, let's see.
What would that be? Be good. First one sticks.
The first one sticks?
Yeah.
How about the Lawyerator?
All right, not bad. The Lawyerator.
That's good.
That means I eat lawyers? Okay, pretty good. Thank you. Okay.
Well, eats opposing lawyers.
Oh, okay. I don't eat my young. I eat opposing lawyers. All right, so let's start with that theme. You get inspiration as you're driving in and you listen to Cliff.
Really?
So, yes,
or sell things.
People do listen to you. World Wrestling Federation. Okay, it's not always like that. There's no fisticuffs in the courtroom, at least not in the courtrooms I practice in, not in Circuit Civil.
Not yet, anyway, right?
Yeah, right. Sometimes you
only bailiffs.
Now I got it in stereo here. Sometimes you get fisticuffs in family court. Sometimes you get fisticuffs in criminal court. Mm-hmm. Not really in Circuit Civil. There we do battle with our words. So let me tell you a little story. I love telling the stories. I hope you like listening to them. This was from, over a decade ago, maybe even close to 2 decades ago. Had a big federal case with, happened to be at that time the chief judge of the Southern District of Florida, a federal judge. So, he's there for life. And he's God in his courtroom. And there's not much you can do about it. Mm-hmm. So there came a point in time where I knew the other side was calling a witness, and that witness had been previously convicted on 2 occasions of a felony offense of lewd and lascivious on a minor under the age of 12. Now, that is not exactly the most credible of witnesses, but you can't really tell that to the jury. The rules don't permit you to unless the witness makes a boo-boo. Mm-hmm. So the smart lawyer, I like to think I'm usually smart, tries to choreograph the dance without getting in trouble. So they call the witness, and I alert the judge, we have an issue that we need to deal with, and could we excuse the jury for a few minutes? The judge excuses the jury, excuses the witness so he doesn't hear what's about to happen to him. And I say, look, this witness has 2 felony convictions, lewd and lascivious on a minor under the age of 12. I understand the federal rules of evidence. I want to tell you how I intend to proceed and make sure that it's consistent with how you'd like me to proceed. So I tell him the first thing I'm going to do is I'm going to ask him, have you ever been convicted of a felony or a misdemeanor involving truth or dishonesty, which is the language you use. And if he says yes, my next question is going to be how many? And if he answers correctly, that's all I get to do.
Okay. All
the jury gets to hear is that the guy's a felon and how many times, which is good enough, but sometimes you want more. I said, but Judge,
would they ever get that information? I mean, if they go, well, what for?
No.
They can't. They're just, that's it. Okay.
If the witness answers honestly about being convicted and the number of times, they don't get to know what for.
Okay.
So I said, Judge, if he denies ever having been convicted of anything, I have here the certified judgments of conviction, and I intend to introduce them to him and ask him, well, isn't it true that you were convicted on such and such a date of lewd and lascivious on a minor under the age of 12?
Okay.
That's how you get it in.
Okay.
Now, if he says, yes, I've been convicted, and then I go, how many times? And he gets that wrong, I can do the same thing. So I went through this whole song and dance with the judge, and the judge very calm. Yes, that's fine. Exactly what the rules tell you can do, no more, no less. So we call the jury back in. We call the witness back into the courtroom, and I go up and I say, Mr. Whomever you are, have you ever been convicted of a felony or a crime involving truth or dishonesty? Yes. Okay. Mr. Witness, how many times? He gets it wrong. Well, isn't it true that on such and such a date you were convicted of lewd and lascivious under a minor under the age of 12? And all of a sudden, you talk about the WWF, the judge who's the chief judge of the Southern District, the #1 poobah, Mr. Address, I'm going to hold you in contempt. Bailiff, get the jury out of here. You can't do that. Hope I didn't burst any of your ears, folks. And I'm, Judge, what are you talking about? I just went through this with you before the jury came back in. So now the jury's gone. I have to get my calm back. You can't yell at a judge. Because even if you're right,
you're in trouble.
You're going to the clinker. So I'm trying to explain to His Honor that I had gone through the choreographed dance with him before he had told me I could do this. I never told you could do this. You can't do that. I said, Judge. And I went through again the rules. I asked him, have you ever been convicted? He said yes. I asked him how many. He got it wrong. And I went to start introducing the certified copies of conviction. He said, that's not what you did. I said, yes, Judge, it is. So we're going back and forth with, well, we're going to proceed, and at the end of this trial, we're going to have proceedings on order to show cause why you should not be held in contempt. And meanwhile, my client has heard this.
The jury has heard it.
The jury, yeah, right. Yeah. The jury has heard it.
When they were dismissed, they thought you were the bad guy.
Oh, you're right, and that hurts my client horribly. So I have to find a way to fix that, or try, or die trying. So we're still arguing. And I said, Judge, you had the court reporter here going through everything I said I was going to do and what you told me I could do. May I suggest we take a recess and go back to chambers and talk to your court reporter and review
Read it back.
I don't have to do that. I know what happened. I said, Judge, I'm really suggesting maybe we take a little bit of a break and we, try to figure out what's what. They don't want to say I'm right, you're wrong, but what's what. So he said, okay, we'll take a break. Okay. So we come back in, jury's still not in the box, and witnesses outside the courtroom. And he says to me simply, let's proceed, Mr. Deputy, bailiff, bring the jury back in. I go, wait, Judge. Let's proceed? How do I proceed? Am I allowed to question the witness with the certified judgment of conviction or not? Yes, Mr. Abdus, proceed. I told you, proceed. I said, now wait a second. Your Honor, if I'm allowed to proceed the way I was trying to proceed, then obviously your review of the transcript verified that I did exactly what you told me I could do, consistent with the rules of evidence. You have yelled at me and threatened me with contempt in front of the jury. And that makes me look really bad. And by extension, when a jury doesn't like the lawyer, very often the client is the one who pays. I said, I'm asking you to give a clarification to the jury when they come back that there was a miscommunication, Mr. Address is going to proceed, and there were no errors on his part in terms of how he was handling the questioning of the witness. I don't need to give any instructions to the jury. Let's just move on. Well, now, I can't force it.
But could you go for is there mistrial happening here?
Oh, I don't want a mistrial.
No?
If I lose the case, is that a point possibly for appeal? Yes.
What you wanted at that point was a new jury.
Not a week into a trial, I don't.
Okay.
Okay? Theoretically, yes, that's a possible point for appeal. So, jury comes back. I figure, how am I going to communicate to the jury without, getting the judge in a headlock, WWF,
Yep.
that I'm okay and everything's copacetic and judge was wrong, I was right. Don't worry about what he yelled at me. Maybe he woke up on the wrong side of the bed. How do I communicate that? And I figured the best way is I'm allowed to proceed just as I was before. In closing argument, I can sort of hint, but a smart jury is going to see I was being yelled at and threatened when I started to do something, and now the judge is allowing me to do exactly that. So hopefully they realize there was something amiss and it wasn't me. So I proceed, isn't this the February, 1927? It wasn't 1927.
Yeah.
You were convicted on Ludum Lascivious, a minor under the age of 12? Yes. And isn't this another copy of a certain... Yes. So twice you've had felony convictions from Ludum Lascivious on a minor under the age of 12. Isn't that true? Yes. Counselor, defendant, whatever, he's your witness again. I don't have any more use of him.
So all of that was just to correct that little fib on how many felonies this person had.
Well, right. If you don't answer the proper number, then you get exposed as to what you were convicted for.
So do you end that conversation with, so in fact you have had more the X number of felonies?
Absolutely.
Okay.
And now what the jury has heard is this witness is a pervert. A convicted pervert.
And a lawyer.
Yeah. And, his testimony is not going to have any value at all. I mean, if they had just heard he had been convicted once or twice of a felony or a misdemeanor involving truth or dishonesty, they use that to whatever extent they want. And, they can give him credibility, they can not give him credibility. You never really know what happens. But when you hear the actual, what you were convicted for, and it's something like that, that witness is useless now, and that's really what I wanted.
Did judges ever doze off
Yes.
and miss something?
Oh, yeah, they do.
Oh,
But, most judges take copious notes.
right.
And most federal judges take notes that are far exceed anything even lawyers take. They can go back to their hand. I mean, some of them are now typing, really. But they could go back in the olden days, to their handwritten notes and say, well, yesterday, didn't Mr. Smith testify blotty-blotty-blotty-blue? And I may not remember exactly, I know what Mr. Smith testified to generally, because it's important, but I don't remember every single word he testified to. The judge has it in his handwritten notes. It's amazing. there are truly great judges out there, and honestly, most of them are pretty darn good. And then you have the ones that aren't.
Mm-hmm.
That's like in any profession, and when they're federal judges, that's a real problem because they're there for life. Anyway, so we finished the trial, and he's about to dismiss us. I said, well, wait a second, Judge. I wanted to get my pound of flesh. I mean, the jury's gone. It's just the lawyers and the clients now. It's over with.
But it's in the record.
Well, I don't care. I don't care in the record. It's not like it goes on my permanent record. No.
There's a file.
If I was held in contempt, it would go on my record.
There's a file somewhere with
Yeah.
all that information just sitting.
Yeah. Maybe they'd find that if I was nominated for the Supreme Court. I wasn't really worried about it. So I said, well, wait a second, Judge. Don't we have another proceeding we need to deal with right now? What do you mean, Mr. Address? Well, Judge, you said when the case was over, we were going to go directly into an order to show cause why I shouldn't be held in contempt. Aren't we going to do that? No, it's not necessary. Oh, it's not? Okay, thank you. I just wanted to get a little something out of him. And I did, and we left. So, that's the World Wrestling Federation in court. I had a federal judge come down on me and threaten me with contempt in front of a jury and my client, and, got to deal with that. So, all right. What else is World Wrestling Federation type about law? We talked before that you get in lots of arguments, legal arguments, some of them very excitable, with other lawyers and with the judges, in the courtroom, especially during a trial.
Is an argument what the whole thing is all about?
Absolutely.
Okay.
Sometimes the logical argument disappears and the kindergartner comes in. Sometimes my adverse counsel and I sometimes it's my fault, I'll admit it. Sometimes we don't play well in the sandbox. And sometimes the judge points out precisely that and warns us, if you don't start playing in the sandbox well, one of you are going to get in trouble. And that's our warning to make sure we behave.
We have a call.
Oh, we have a call. Wonderful.
The mysterious note from the hall.
Yeah, the note that I can't read the name.
No,
I just saw hieroglyphics.
It's a little different. It's John.
Okay. Hi, John. How are you? How can I help you?
Good morning. I think I've heard you say before you're familiar with condominium associations. Is that correct?
Yes, that's right.
Okay, I have two questions. The first one is regarding notification. In the old days, you would have to send certified mail. Does the statutes consider email the same as certified mail?
Well, it depends. Who are you trying to serve, and what are you trying to serve?
Well, I'm not sure yet. I mean, if it's something serious is what I'm getting at. If you need
All right.
to notify the board of directors and you're concerned about a serious issue, would the email be considered legal notification? I guess that's what I'm asking.
If you're not talking about being in an actual litigation proceeding where you have to serve in order for them to, let's say, respond to a complaint or something like that, then yes, email is absolutely just as good usually as anything else. And in fact, I usually tell my clients, if we're preparing for something that may prove into litigation, that you want to give notification in some way where it's clear that you actually did give notification, whether that's an email, whether it's a fax, whether it's a hand-delivered letter that somebody signs for. I hate, really, it happens all the time because people aren't lawyers. And, of course, I screw up things in my house. That's because I'm not a plumber. But, a lot of people call our office and they say, well, I told, and usually my paralegal in the screening process is, and did you put that in writing? Did you do an email? Did you do a text? Anything? No. And I begin to groan. Sometimes it could be fixed. It's not too late. Sometimes it is too late. And then it doesn't mean they won't win. It just then it becomes he said, she said. Mm-hmm. And those are always less reliable. But you're talking about, trying to preserve some notification, some proof that you either objected or what have you. It sounds like possibly prior to contemplating, or filing any action. then yes, email is just as good because there's proof then that you put them on notice.
And the second question is, with this new law going into effect, I believe the first of the year was delayed. I think it was supposed to go in June, where they're supposed to put all the condo association records online. Does that include, like, we have a folder for each unit? Does that include that folder, that personal folder for each unit?
I'll be honest with you, I'm not really that well familiar with the online requirements of condo records. So
Well, let me ask you one other
can't
thing.
honestly
Maybe
answer
you can
that.
Maybe you can answer this.
Sure.
In that folder, I'm sure you're familiar with, condominiums have a folder.
Oh, yes.
Unit 2101, for instance, and they know who lives there, they know how long they've lived there, any fines or any disciplinary action or anything goes into that folder. What right does the unit owner have to inspect it and then say, look, this is irrelevant, you shouldn't really have this in there? Do we have any rights as far as
Well,
that goes?
the unit owner usually has a right to inspect records that are set forth in the statute that the association is required to maintain. That is what their right is. If there are other records that are within the folder that aren't requirements under statute, then they don't really have a right to access those unless they're involved in litigation and you get a request for production of documents or you get a subpoena. Then we're talking it's a different story. But unit owner generally wants to come in, and gives proper notice and to inspect records. That's permitted to the extent precisely as to what is set forth in the statute. And the statute is really very clear as to what the associations, whether it's condo, homeowners, mobile home, what they must maintain and what records must be available on what notice, to unit owners.
Okay, and that's that long section of the statute.
Yes, it is long.
It's in one of those subsections. But they have to
Yes.
And one last question. If they argue with you and say, well, we think it should be in there. I mean, that's just it. Is it worth the individual going out and spending a lot of money over something not that serious to argue over what should be in the file and what shouldn't be in the file?
Well,
Because
see that.
I've gone in.
Yeah,
I've gone into the office and, these files are readily available, and they always give me the line, well, you got to put it in writing. And I said, well, I can understand that if you had to go, research this and dig it out of somewhere, but there's a filing cabinet you're standing right next to, and that's where the folder is. In the old days, we had a manager, he was very friendly. He'd say, sure, here. Today, everything's in writing. I don't know if that's to cover their, their cell.
Well, it
You're
is.
afraid you're going to bolt out with a folder.
Because of lawyers like me. Yes, everything is documented.
Yeah.
Now, who puts information in this folder?
Usually the board of directors or
And
the property
what
manager.
if there's
Usually
someone
the
on the board
property
you're not
manager.
getting along with?
Well, that's always the problem. It's always the call we get.
Okay.
The president doesn't like me, and I'm being harassed.
The thing is, 20, 30 years ago, the Department of Condos and they had an enforcement department that had a little more teeth to it. Today, they've written that out of 10
That's
years
because
ago,
nobody has any
2008.
budget anymore.
Yeah, so they've written a lot of stuff out, and there's really no place to go to it. There is no protection agency anymore for condominiums.
No, what you do is it's
Even homeowners.
litigation.
Yeah.
And you asked
Right
me
of it.
you asked me the question, is it worth it? That's really more of a practical question. I ask prospective clients that all the time. They may come to me with something where something is not being done properly. Either they're the unit owner or they're actually the association. And I say, look, this is what the law is. It's very clear. And now you have a practical question of whether or not you want to, let's say, bow to a silly demand of a unit owner, to put some piece of paper in his file that is not required. It's not mandatory. He has no authority to force you to do it. But if he's the type that you really know he's going to go hire a lawyer and he's going to sue the association, and the association's going to incur $5,000-$10,000, in trying to get through this, then it becomes more of a practical question than a legal question.
Exactly, and you got to show you're willing to do that, and that's always the hard part. But thank you for your time.
Thank you very much for your question. I appreciate it. So those are really interesting questions.
Well,
and-
I learned something. I had no idea that the condo association had a file on every unit.
This is 1984. Don't you remember?
No,
It's
that was a long time ago.
so 1984 George Orwell. It seems to be coming true in 2018. But I won't go further into that issue.
Oh no, I mean you're exactly right though. Everything.
But
Cou-
I'm
couple-
right. I'm right from a different perspective than you are coming from.
Couple of keystrokes and it's all there.
Yes. Well,
Everything.
there's a lot more happening that's more 1984 than that. But okay. So yeah.
I'm going off the grid.
Okay. Good luck.
I know,
Try.
I know.
You want to get a cabin in
I don't know
Utah,
if I
maybe?
want to give up my iPhone. That's
See,
the only
see,
way.
see?
Only way
Okay.
off the grid, people.
Yeah. So those are very good questions. I think we once talked about homeowners condo law, and those questions come up from time to time.
So it's pretty complicated when you enter into that agreement with that building and the people who live there.
It is. All these associations, look, I mean, there's a phrase for it. It's not always fair. Very often it's very fair. The condo commando. Mm-hmm. The person who has nothing better to do
Right.
than look to see if your grass is a quarter of an inch higher than permitted
Yeah.
under the rules and regulations, and then report you. Those things drive people insane. And the smart association gets these silly complaints and doesn't act on them.
Mm-hmm.
However, sometimes they give these warnings and requirements that you have to cut your lawn or we're going to fine you. And
Yeah, I love the flower pot on the patio
Right, yeah.
deal. Yeah, no flower
And-
pots on the patio.
sometimes these things get rather expensive, both for the homeowner and for the association. And I've represented both. It's really better idea to keep things to the way they're supposed to be and not petty. But sometimes then you do get people that get themselves put on the board for the sole purpose of going after somebody.
Sure, make everybody's life move.
Well, not everybody.
Somebody. Targeted
Oh, yes. And then usually it's a harder time, and you have to engage in a fight because there's no easy way to remove that person.
What about things that the board might want to do that residents don't think need to be done, like say blacktop on the driveway
All right.
or repairs to something that they don't think it's time to do?
Condos, homeowners associations, mobile home associations, there's 3 different statutes, but their essential documents are all the same. The Declaration of Covenants, the bylaws, and the rules and regulations. If what the board wants to do is consistent with those documents, they have the right to do it, and you elected them to make those decisions. If they're going beyond it, there are areas of all these 3 statutes that say certain things must go to the members to vote. And if they take action on one of those things without giving you a chance to vote, you have the right to seek to invalidate that vote and pursue a matter. We have Dan on line 1. Hi, Dan. How can I help you?
Morning, how are you today?
I'm doing good.
Yeah, I got a quick question. One of the businesses I own, I had an independent contractor working for me as a auto mechanic, and he provided his own tools and came and go on his own schedule. And he decided to leave the business, which is fine. It took me about 2 months to get him to come take his heavy tools out. I constantly was calling him, asking if he needed them. He finally did, and then a couple days ago, I went up to my second, to the loft on the second story of the shop, and I find all kinds of personal boxes. I don't know if he's abandoned them or left them there. What is my responsibility in the proper disposal of that stuff?
These had nothing to do with his job obligations?
No, they're like boxes of his pictures of his children and personal items.
Legal obligation? Honestly, I don't know that you have any. To protect yourself always from, people don't want to buy into a lawsuit, even if they're right. If you do the thing that is legal but maybe not the best thing morally, sometimes you get yourself sued. And even if you're going to win, you're going to pay lots of money. Look, I would give the guy notice, certified mail, of what he has. give him one, maybe two opportunities to pick it up, and if he doesn't, dispose of it.
I appreciate
But I would
the
make sure you
advice.
don't dispose of anything that is truly of significant value without going through even extra steps.
Should I then go through these boxes to determine that?
Oh, I think you have every right at this point to go through those boxes to see what is in there. For all you know, there may be some of your property in one of these boxes.
Well, that's true. I didn't think about that.
Yes, I think you have the right at this point to go through those boxes, to do an inventory, to give him notice, opportunity, and, if you're throwing away, essentially junk, that's one thing. If you're going to throw away, a $5,000 piece of equipment, that maybe even be fit in a hand, I might go through a few extra steps before I dispose of that. Not because you can't, but because if he sues you, you may be right, but it may cost you a lot of money to prove you're right.
I understand. So thank you so much for your advice.
You're very welcome. Thank you for calling. And we have on line 2 our number one, our favorite, who he has not called for a few weeks. I hope he's been doing well. It's Mr. Bulldog.
How are you doing?
I'm doing good. How are you?
Hey,
Mr. Bulldog these days.
Yes, Mr. Bulldog.
soon to be changed to Dr. Bulldog.
I apologize for the incorrect honorific, Dr. Bulldog.
Soon to go. I will soon graduate, and then you can call me that.
All right.
So, it's totally off subject, sir. I have to relate a funny story, and
Sure.
This is something that just happened today. I was looking at, phones from a cell phone company whose name I won't mention, but it starts with a V.
Okay.
Anyway, so...
Veronica.
Not me.
Yeah, exactly. Veronica sells phones. Out of
By
her
the
truck.
I
seashore.
have my own line.
Oh, that's good. Anyway, so the point is I'm on there, and then I engage in this little online chat deal. Because I'm seeing what they can answer, because I need certain gig
I got you. Yeah, I got you.
I'm looking at plan rates and everything. And then I said, well, okay, thank you very much for your help. I think I'll call my local store, talk to a tech, and get my actual gigabyte requirements for online data. And, because they know a little more than this person does.
Right.
And so I leave that one hanging, open another window, call the store and everything. We have a nice conversation. He says, do this, do this. And then I come back on. She's already ended the chat. And in my email, I just purchased the phone.
I don't know how you purchased a phone unless
Wow.
you said you authorized it.
I know, exactly. I had to call customer service and said, I didn't authorize it.
Yeah.
You know?
Yeah. You had a very aggressive salesperson.
Wow.
Oh, my. No, it was, excuse me about these online people. I always get that gut feel that I'm actually talking to a computer generated versus a real.
Sometimes I'm not so sure if you're wrong. And give it 10 years, and you may very well be right.
I'm just telling you, watch out, because I got slammed
Yep.
without authorizing.
That happens, and we do get, on occasion, we get calls like that.
Yeah.
And, it's usually easy to reverse.
Well, yeah, and I just called customer service, but I was like going,
Yeah.
the heck is going on here,
And if the customer service then just fixes things for you with no problem at all, they're aware that you didn't want that and that took place.
Right.
They're aware of that.
Absolutely.
Well, now, in terms of that, when he starts doing comments, I'm like saying, you put this in comments because I want to see management review this. Because I think that sort of behavior is unethical business practices.
It's
That-
predatory business practices.
You're right, and depending upon what happens, sometimes we use the word Unfair and Deceptive Trade Practices Act. Triple damages, attorney's fees, confetti goes coming down from the ceiling.
Well, I was lucky because I called the customer service and canceled
Right.
it before the order went through. Now, if the order had gone through, now I've got a problem because I've got a different bill and a new phone and everything that I didn't ask.
And you're lucky you weren't dealing with a company in China.
Well, it doesn't matter.
Oh, it
what
does
kind-
if they're in China.
Oh, you
Trust
can't
me.
You can't sue
To
China?
sue, oh, you can, but I'm doing it right now. It takes 2 years to serve any corporation in China because the Chinese government doesn't like complying with the Hague Convention, and you have to have all the documents translated into Mandarin. Trust me, you don't want to have to try to undo this
Wow.
with a Chinese company.
Yeah.
Well, that's a very interesting point. I'll try to remember that if we ever get, in the Hang Seng market.
Yeah,
or whatever.
there are actually companies that specialize in helping attorneys go through the process of serving in China. There's a cottage industry.
Doesn't
Wow.
surprise me at all. Thank you and have
You're
a
welcome.
nice day, sir.
Take care, Mr. Bulldog, soon to be Dr. Bulldog. Okay, very interesting. So, dealing again, I guess we're sort of off topic, but that's fun. I like that. And it's all because of Cliff, because he mentioned WWF,
Cliff
and
did it. Yeah.
he mentioned something else next week. We may be diverting next week too. And hey, what can you
Get
do?
thinking on that, Cliff.
So there are two cases where one I'm about to file, one I'm most likely going to be about to file, just a little more hesitation. And you sort of wonder, especially on these contingency cases where I'm not going to get anything unless
Okay.
I get some money, and you're looking at certain types of cases are going to take hundreds and hundreds and hundreds and hundreds of hours. You're in it for the long haul, unless there's an early settlement, and that's not often likely in certain types of cases. So one of them is, and I don't mind saying it because I've put them on notice, they know it's about to happen. I sent them a copy of the complaint saying, do you really want me to file this? And they know it. About to sue the state of Florida, Department of Corrections, and its medical services provider in a class action for failing to provide surgery to an inmate who had a hernia and who had 2 separate recommendations while he was incarcerated that it required surgery. He was in too much pain and it could get a lot worse. Now, the interesting thing is, in this case, just the year prior, there was another lawsuit, class action, against the state of Florida and its prior medical provider for the exact same thing. And Florida settled it. And as part of the settlement, they agreed to enact new regulations, new rules, new policies, new procedures to make sure that people with hernias, exactly the same thing.
Okay. So they were specific on the
Right.
on the ailment.
Yeah.
even.
So 1 month later, my client is seeking, just coincidentally, surgery for his hernia. And they don't give it to him. And eventually he is released. And within a week, an outside doctor has him in surgery. So, to me, why am I going to take on a case like that? If it wasn't for the fact that there had been a class action just a year ago, if it wasn't for the fact that the state of Florida Department of Corrections had already agreed that it had been wrong in how it handled requests for surgery from inmates who had hernias, and if it wasn't for the fact that they chose in that litigation to settle the case, and if it wasn't for the fact that the policies that they decided to enact and which the judge signed off on would have protected my client who sought surgery a month later, if it wasn't for all those facts, I don't know if I would have taken this case. But to me, in evaluating it and thinking of if we ever do get to a jury, a trial, the case isn't at some point settled, which I hope it is, and more than 90% of all civil cases are settled. But I have to think, if we ever get to a trial and a jury, what argument, what story, what narrative am I going to be communicating to the jury? What is my theory of the case? What is the argument I can make in opening statement and bring it back again in closing argument to tie everything together that will hopefully capture a juror's imagination, stick with me, and then if I've proved what I said I was going to prove, find in the plaintiff's favor. And here, when I looked at it, I could already hear myself in my sleep doing my closing argument. And it was that they had just settled this a year ago. It wasn't for one person who didn't get a hernia. It was a class action. And they agreed to X, Y, and Z. And then a month later, they didn't do it. I think, my opinion, that the average juror that might be seated on the jury would be enraged by something like that. And I have to take into account, whenever I handle a case that involves somebody who is or was incarcerated, you're probably going to start off with less sympathy from the jury. Okay? And you have to find a way, can I overcome that in some way to get the jury on my side? I mean, you're suing the state, the Department of Corrections, and as much as people might yell and scream police misconduct, and you hear it all the time on the news, the truth is, and there have been studies that support this, that when you get into a courtroom with a jury, the average juror wants to and does give the benefit of doubt to law enforcement. They want to believe that if they were in a situation where they needed help from law enforcement, they're going to get it. Not that law enforcement can't be relied upon. So you have to look at, can I overcome that? And how likely do I think I can? And here, with the state agreeing to certain procedures and paying money that were in the millions and millions and millions and millions of dollars, most of the attorneys, of course, and attorney's fees, it seems to me I have a narrative to tell, a story to tell, that despite the fact that my client had been incarcerated, and they'll never learn what for, as long as he answers those proper questions, if he ever gets on the witness stand, have you ever been convicted of a felony or a crime involving truth or dishonesty? Yes. How many? The right number. And dang it, I'll make sure he's prepared if we ever get there.
Just kind of the nature of this case, though, they would already know that he's been incarcerated.
Yeah.
On this one,
But
yeah.
they want the jury to know. But the point, and I would probably be telling the jury an opening statement. I'd be getting it out in front of it,
Right.
and explaining that this is not a case about that. This is a case about what are your Eighth Amendment rights. Medical care, not be subjected to cruel and unusual punishment. Even though you may be incarcerated, hopefully I will never. You do maintain certain rights, and look, in a civilized society, you should. And we hold ourselves out to be that type of society and the rule of law. And, not everything should be rosy and peachy keen in a jail. I agree. And you don't need...
But it's far from civil in there, too.
It is far from civil.
Yeah.
But there are certain fundamental, essential constitutional rights that should not be taken away. And that is, if you are in serious need of medical care and in pain, to have those needs addressed in a prompt and reasonable manner. And here, just a year ago, the state of Florida said, we agree, and then didn't do it. So, that sort of, to me, that's a WWF case, because I'm anticipating it'll never get there. It'll never get to a trial. The last one didn't get there.
And really, it shouldn't, because, I'm sorry, didn't they learn from the first one?
And that's what I asked them. I wrote to them. I said, do you really want me to file a lawsuit? How could you want me to file this? Well, I guess they don't believe I'm really going to do it. So we're going to do it. And then I guess, we're running out of time, so I'll just tell another quick little story. I won't go into too much detail, because although they should know they're about to be sued too, it's a little bit closer to home. I represent somebody that is presently incarcerated and is essentially a career criminal. No doubt about it. Is not a nice person. Tried a couple years ago, somewhere locally, to rob an ATM machine. Agree, shouldn't have been doing that, that's for sure. Police were called. The first officer that shows up on scene sees him. He starts to run to his car to escape. The rules of the police department basically say, when in terms of using deadly force or possibly deadly force, here are the situations you can do it. Now, among those are, you don't shoot at a moving vehicle unless you need to preserve the safety of others, like the public. Well, here it was, 5 in the morning, and there was nobody else around, and he just wanted to escape. They could have pursued, and there was no reason to be shooting in the first place. But even that, if that was the case alone, I don't think
you don't get to shoot them because they're running away.
Right. But if that were the case alone, I don't think I would have taken it. There would have been lots of disagreements, and I don't know if I would have taken that case, honestly. So what is making me on the verge of actually filing a lawsuit? I have to see my client in jail and go through final steps. He was shot in the back. He was not armed. He did have what was called I don't even want to describe it because then it gets too specific. He had something that was not really a weapon. Let's just call it a shoe that he threw at the officer, hit him in the ankle. The officer then thought he was under attack and started firing. And it's clear, not anything that you see in the police records at all. I got to go into the medical records now when he was rushed, by helicopter to a hospital, that the first shot hit him in the back as he was trying to get into his car to escape. I'm sitting here honestly as a lawyer who practices civil rights law. No. I don't care what this guy has done. I don't care if he's been convicted of 27 felonies in his life. I don't care if he spent 90% of his adult life in jail. And the second he got out, he decided to try to pull something like this again. I don't care. And I know there are a lot of people out there that disagree with me. And I respect it, but I disagree with you. I don't care. To me, the shot in the back is what will make me take this case and file it, because the story that I will tell, if it ever gets there, and I don't think it will, in an opening statement or closing argument, the narrative, my theory of the case is the shot in the back. That is, anywhere really, but in our history, you go through even stories, poems, songs, that is cowardly. And not only was he shot in the back, he was then shot another 5 or 6 times. In the jaw, in the arm, the face. He was in his car at that time, and the officer shot into the vehicle. We can go a lot into that as to maybe there was somebody else in the vehicle that the officer couldn't see because the windows were tinted, and should he have been firing? Maybe he had his little 8-month-old baby in there in the passenger seat, which he shouldn't have. Maybe if he fired into that window, he would have killed the baby. All these questions are questions I would ask, in a courtroom. Did you know? Could you have told? Isn't this a risk? How could you have violated policy that way? But to me, the essential reason for this case and why, I'm on the verge of being willing to embark on potentially hundreds and hundreds of hours for a guy that I absolutely dislike, make no two bones about it, is because, no, you're not going to be shooting anybody in the back, and if I have a chance to do something about it, that's not going to fly. So I can envision the war that will be started once I file that suit, because I know, given the police department that is involved, I know who will be representing them. I know who my opposing counsel will be. I have dealt with him before. It will be war. We don't like each other. It will be yelling and screaming on the phone. It will be fun. But, that's about what's to happen. And so sometimes the practice of law really is like the WWF. And just as we get ready to go, a very, very, very quick call.
You've got 3 minutes left in the show.
3 minutes.
Yes.
Okay, Russ on line 1. Shoot. Oh, I didn't mean to say shoot.
You're not running away, so I can't.
All right.
Oh.
So, how's this guy? They know he's a criminal at this point, I'm guessing. But if this criminal's running away, jumps in the car and drives in and smashes into your car, going out to dinner and kills your children, I mean, there are so many factors you're not applying to this. He's not a coward by shooting an absolute criminal in the back.
It is when it violates the department's own policies and procedures for use of potentially lethal force. It is when you take into consideration that this was at about 5:30 in the morning on a holiday and there wasn't a soul around.
Yeah, I guess there are factors you got to work in.
Yeah, and I will agree with you that if this was at 4 o'clock in the afternoon and immediately, in the main thoroughfare outside the bank was rush hour, and this guy was trying to escape into that mess, do you have a right to shoot? I might err and say, yeah, I can understand it. So I do understand where you're coming from.
If I were emperor, I would require anybody over the age of 9 or maybe 2.5 feet that tries to run from a police officer, they are required to shoot them. So hopefully you won't have to make me emperor.
you and I would be on opposite sides of the fence on that one, but that's the great thing about the First Amendment. I respect your right to make the argument, and as Patrick Henry said, I will defend to the death your right to say it, but I disagree with you completely.
Well, if you're running from a police officer, you're probably not contributing a whole lot to society.
Maybe, maybe not. Maybe you're running because you're scared. Maybe you're running because you don't speak the language. Maybe you're running because you're an undocumented worker. Maybe you're running because you know that they're about to separate you from your kids under current policy. I don't know. It could be all sorts of reasons.
Yes, but the policy has always been in place.
Yeah, well.
You got 1 minute.
All right. So thank you for your call. Thanks. And we're going to sort of wind down now. We got 1 minute.
Yeah, a minute.
Thank you, folks, for the calls. I really do appreciate them. It makes it more enjoyable. This is... it
does take you in many directions,
doesn't
it?
This is our 27th episode.
He's counting.
So, no, I am. So we have now done 6 months. I've been on this show for 6 months, and I have enjoyed it, and I intend to continue with it. I hope you will continue with me and tell your friends. If you have questions, call us here on Fridays at 10, or feel free to call my office. The area code is 772-781-8003. And thank you very much. Have a great weekend.
This is WPSL Port St. Lucie.